just a couple of quick matters from the morning. So there was a question from my Lord Justice Holgate about the collection arrangements under the central list. The answer is the sector is spent.
Yes, I noted. Yeah, thank you.
In terms of timetable, I've had a healthy discussion with this morning. I think it wouldn't cause difficulty if I finish at 4:30, so I'm going to extend, if that's okay, until then. I'll obviously try and cover it as quickly as I can.
I'm getting a scent with a pained expression.
Right. So I didn't hear what time.
3:30.
3:30. Thank you.
And I'm going to make, in order to deal with things as efficiently as possible, I'll make a slight tweak to the order I offered. I had a section on the Upper Tribunal's decision. I think we've probably laid a lot of foundations for that, so I'm going to park that and amalgamate that with my submissions so that I can spend some time on the authorities, which I think may or may not assist the court to see in particular how the concept of let out has been not discussed in advertising but discussed in railways, and the extent to which any of that assists in terms of the approach that the memberships are being asked to consider. So I'm going to treat my historical section as being completed and move straight then to the section of my submissions dealing with case law. And I'm going to start on the advertising cases, and just to be clear on this, it's common ground on the skeletons that there is no advertising case that actually considers what the concept of let out to someone other than the rates for occupiers means in an advertising context. Can I show you what we do have? But so obviously I'm going to try to deal with it briefly because it doesn't directly assist, but just to cover the ground of what is available in the advertising context. So the first case is the case of Peak, which is at page 179 of the bundle behind 18. It's a short decision of the Lands Tribunal, and the holding of it was, it concerns an advertisement. You can see from the head note. The company owned a block of flats, let one to a service tenant and two others on leases, which contained a prohibition against the exhibition of advertisements, but no reservation to the company of the right of such exhibition. The company's wholly owned subsidiary obtained planning permission for the erection of an advertising sign on the end wall of the three flats, and the sign was erected. And it was held that the tribunal wasn't prepared to hold that it was let out, because no deduction could be, nothing could be deduced from the erection of the sign per se, that there had either been an express reservation or a letting out of it. It's clearly a flank wall sort of paradigm situation, and insofar as the decision of the member assists, in the right hand column you'll see on page 179, you'll see the reference there at the bottom of the right hand column. The question at issue is whether the sign constitutes a separate hereditament under section 56 of the 1948 Act, and then the submissions of the various parties are set out. And if I can pick it up on page 180, so far it assists, the member says, whilst it may well be that the parent company and their subsidiary, the ratepayers, are so closely interwoven as to be almost indistinguishable to the general public, yet in law they're two separate entities, and planning permission for the erection of the sign was given to the ratepayers and not to the parent company, and in my view the occupiers of the sign are the ratepayers. At the time the sign was being erected, or about to be erected, I think that the occupiers of each of the three flats to whose wall the sign is affixed could have raised objection. In fact, they did not do so, and after this lapse of time, it may well be that any action on their part would be stopped. Because this sign had been erected, the valuation officer asked me to assume a rent between the parent company and the ratepayers, and to read into the lease of the flats an implied reservation for the erection of the advertising. I do not think that the fact that the parties concerned failed to avail themselves of their rights means that I can imply either a letting or a reservation. And I find that the requirements of section 56 of the Local Government Act and the right to use land within the Act that should be let out or reserved have not been complied with. So they weren't prepared to imply it, but beyond that, it doesn't tell us anything, and it's obviously it's a frank archetypal situation. So I don't think anybody's suggesting we can take much from Peak, but that's that decision for what it's worth. The next advertising case is the case of O'Brien, which is a decision of this court in 1996. This is at tab 21, page 222. It's another Frank Wall case, and I can call it that, of archetypal advertising. There was argument in the Court of Appeal. This is on a case stated from the Lands Tribunal. The appellant acted in person, and the Court of Appeal was greatly assisted by counsel for the valuation officer, Lord Justice Holgate, as he now is, but he wasn't called on in all the submissions. The judgment contains a useful overview of some of the history of the provisions, and I'm not going to go over that in detail because we've covered a lot of that, but it doesn't directly assist on what let out means in an advertising context. The issues in the case, just to kind of orientate the court as to what this does decide, the issues are listed at the top of page 224 using the numbering in the authorities manual. So whether an agreement between InStyle and the appellant created a right ratable as a hereditament, whether the hereditament, if any, was located in the rating district, because it was argued that the incorporeal right wasn't located within the local area, and whether it was occupied. And the court dealt with that fairly shortly. As I say, it sets out the history of the various provisions at 225 and 226 using the authority number bundle numbering, and then picking it up at 227, it deals fairly shortly with the points. And 227, second paragraph there starts, as I say, the substance of the first point is whether one should look at the wall upon which the fixture is placed as being the land referred to in section 64.2, or whether one should look at the fixture itself, which, as the appellant rightly points out, comes with the definition. In my judgment, one should do the former. The appellant concedes, and inevitably, that if a right is let out, were the right to paint on the wall and advertising extolling the virtues of some borough, then that could be manifestly squarely within section 64.2. But he says that there's a drafting quirk in section 64.1, that result is avoided, and then that argument is rejected, and then they pass from the first issue to the third issue. The right which we're concerned with is an incorporeal hereditament, and then reference to the deeming provision, and then it's said to be obviously occupied in accordance with the deeming provision, and then it's expressed Parliament clearly, if one looks at the Act as a whole, which is a proper way of approaching it, intended someone in the appellant's position to be taxed or to be rated for the right that he has. So there's no express consideration of let out, and it's also, if you like, the paradigm case of the right with no connection to the occupation. But there's obviously a very useful distillation of some of the history, which I hope is consistent with the submissions that I've made already in terms of the way that the right came into existence. And then the final advertising case is the one that I've trailed already, and I'm certainly out of chronological order here, but this is the House of Lords decision in the Imperial Tobacco case, which the court will find tab 19, page 181. And again, just to sort of say what this is going to help with, and then I'll show you the critical extracts. But in this case, the letting out was conceded. This is a valuation case. It was about the Section 56 as it was originally enacted. The majority of the House of Lords found that it was the right which was valued, irrespective of whether it had been exercised, and that there was no provision to capture the value of the structure. And there's a dissent from Lord Denning, who thinks that's not a sensible way to read the Act, and as the court will recall, this is the provision that was reversed in the 1961 Act. So it doesn't touch on our issues, but insofar as I think there's some reliance on some extracts from this. So can I just show you very briefly the majority speech of Viscount Simmons, which we pick up at 184 in the authorities bundle, and I'll just take selective extracts from this to give you the flavour of it. So Viscount Simmons at 185, at the top of the page there, he says the writing question is advertising right. It is correctly described, and I think that if that description is kept firmly in mind, the difficulty in the case disappears, and then he surveys the facts, and over the page at 186, he decides that if I pick it up just about halfway down, there's a sentence beginning whether it was exercised or not. Whether it was exercised or not, and if it exercised, whether it was on a mean or average scale, it was the same right, no more, no less, and failed to be valued accordingly. That is why I said at the outset of the opinion that it was essential to look only at the right and turn one's eye from the physical aspect of the method of its expression. So that was the pre-1961 amendment majority approach. And it's in that context that the observation that's referred to in the valuation officer's skeleton argument. So just give slightly more context, if I'm right at the foot of page 186, the grant has its value irrespective of whether it is in fact exercised, and it was the grant which is the rate or hereditament, not the exercise of the grant. I agree. So he's approving the Lands Tribunal's decision in that case, which was reversed in the Court of Appeal and then reversed again in the House of Lords. And it's in that context that the observations made, this is on 187, 2/3 of the way down. I do not doubt the result which I have arrived at marks a departure from the usual course of rating law, but the language of the relevant section is unambiguous, and I do not feel justified in ascribing to it any other than its natural meaning. Well, that's a comment about the valuation approach of section 56 as it then was and as it now no longer is. That's not a comment I would respectfully submit that can be read across to the concept of let out. But that's what the Viscount Simmons said in any event. And then Lord Reid, Lord Morton concurs, Lord Reid concurs, and he says, I pick it up at 189, just takes the same approach. The better answer, that's in my one, that's just halfway across by the top hole punch, so about just under halfway down. The better answer to the respondent's argument is, I think that section 56 does not require the valuation of the property which is being used, it requires the valuation of the appellant's rights. That's on all fours and Viscount Simmons. Lord Cohen concurs, and then Lord Denning dissents. His speech starts at page 190, and he frames the question at the top of 191. The crucial question to my mind is what is the hereditament which falls to be valued, and then he takes a different approach, and his approach, if we go to 192, involves asking the question right at the foot of the page, such being the position before 1948, what was the object of Parliament in enacting section 56? Reading the section as a whole, it seems plain to me that the object was only to alter the incidence of liability, so as to place the liability for rates directly on the advertising contractor instead of the occupier of the land, but not to alter the basis of assessment. Now that's a speech of a minority, but he is trying to have regard to the object, which is basically to not change the fundamental approach to the valuation. For his part, he linked his analysis, his dissenting analysis, further down that page to the position under the general rating law. So that's again just below the first hole punch, under the general law of rating, you never rate the physical thing, you rate the occupier in respect of his right to use it. There are many cases in the books where a contractor has been granted a right to erect a structure on another's land and to use it for his own exclusive purpose, such as bookstores on railway or huts on building sites. And then he then goes on to say, in these circumstances, it seems to me that all Parliament did by section 56 was to place advertising structures on the same footing as other structures on the land. Now, for my part, I don't invite the court to take anything positive from Lord Denning's analysis. It's a minority speech. It's relating to a valuation provision. He thought it was useful to draw on the general law of rating in ways the majority, Viscount Simons, didn't, but they were dealing with a fundamentally different question on an assumed basis that there was a letting and where the existence of the hereditament wasn't an issue. So my submission is that although this is interesting, it doesn't really help this court to decide the issue before it.
If we just see what happened in the 61 Act at page 66 of the bundle.
Yes, sorry, I went over that quite.
Well, yeah, but we wouldn't mind looking at it again, if you wouldn't mind.
Yeah, of course.
Because subsection 1, it's really about valuation, as the marginal note says.
Yes.
In valuing any right which constitutes a separate hereditament by virtue of section 56, so it's not changing that aspect of section 56.
No.
It simply says the rent at which the hereditament might expect to be let shall be estimated on the footing that it would include a proper amount in respect of any structure for the time being available, notwithstanding that the structure was provided after the right was let. So does the right have to be exercised? Is it not just, I mean, the word rating is used in two sentences. One to refer to the liability, the other to refer to quantum or the rateable value. Isn't this just simply saying that what is rated still is the right?
Well, I don't dissent. I certainly don't dissent from that. This only goes to what you're valuing. The subsection 2 goes to when this comes into existence. Notwithstanding anything said in that, the separate hereditament shall be treated as coming into existence at the earlier time, which either any structure is erected after the right consumer has been let out, or reserved for enabling the right to be exercised.
It's that which defines when the hereditament comes into existence.
Yeah, so I think you need to read both together. It's explained very well, if it helps, by Ames.
Ames.
Yes.
Okay, thank you. Sorry.
Thank you very much. So, my lords, then I'm going to go, please, to. So I'm now moving away from.
And it's the notwithstanding anything in section 56. So this then reading the two together creates the sole basis upon which the hereditament comes into existence.
And is valued.
Yeah.
Yes, I agree.
Okay,
Yes.
thank you.
So I'm moving. So that's all the assistance you get, which I'm afraid is almost none from the advertising cases. But I'm going to go to two cases.
But sorry, just before we leave section 9.2.
Yes.
It's the right which is rateable, but it doesn't come into existence until a structure has been.
The earlier two events, which is one of which is the creation of the structure, and then when there is a structure.
You say creation of the structure.
A structure.
So that, but you're still valuing the right.
I know exactly.
And if you have a structure, are you still valuing the right which may be capable of being exercised in relation to further structures?
No, my submission is.
What is it in the subsection that stops that?
No. Can I borrow Amy the explanation in Amy's, which is 575? And I'm sorry if that's cheating, but at 575, right towards the foot of the page, Amy's. This was corrected in 1961 by the provision that the value was to include a proper amount in respect of any.
So sorry, 575.
575.
Just where are we?
Right at the foot of 575.
Yep.
4 lines up. This was corrected in 1961 by the provision that the value was to include a proper amount in respect of any structure available for use by the occupier for exhibiting advertisements. So though provided by him after the letting or reservation of the right. And that's a reference from the footnote to section 9, 1961.
Did this provision find its way into the 67 Act?
Yes, do you recall it was section 28, subsection 2.
2, okay, but not in the 88 Act. May not matter, but
I'm not sure. I'm not sure about that. Can I come back?
But in the event, it's a valuation.
It's a valuation.
It's a valuation point.
It may be in regulation.
Because in fact, that's what the House of Lords decision was all about. Difference in the rateable value of £165 and £160.
Exactly, and it assumed the letting wasn't a flankable case. So it gives us some clues, but it doesn't really help. It obviously was much more germane to the argument in O'Brien, where it obviously dealt with the nature of the right in a way that was germane to the question of whether or not there was occupation in those circumstances and where the right was located. In our case, it's a little bit more remote, I would respectfully suggest, from critical issues. So just to then orientate where we are in the argument, I'm now going to move from advertising, but I'm going to stay in railways, and there's two railway cases that I want to show the court, Southern Railway and case, and these are dealing with the provisions for under the railway, which are the predecessors to what is now Regulation 6 of the 2005 Central List Regulation. Obviously, it's been through a number of iterations, but the point I make is that some of the wording is constant between those, and the concept of let out so as to be capable of assessment is critical to that. And immediately before the short adjournment, my Lord Justice Nugee put to me that there wasn't a difference between let out and let out so as to be capable of assessment. That is my case. That's different from what the tribunal did. That is very much my case. My case is that the words let out carry with them the concept of separation, which has had expression in rating case law, in particular in a railway context, which may well need adaptation to advertising rights, but the tribunal was wrong to find it into the system at all. And may I go to Southern Railway, which the court will find tab 17, page 121. Now this is a seminal House of Lords decision for the general principles of rateable occupation, until it was considered very recently by the Supreme Court in Cartronics. It was generally regarded as, if you like, the one-stop shop for the principles of rateable occupation. The Cartronics decision, which I'll show the court briefly in a few moments, said that this was an indication of general principles, and that actually Lord Russell in particular had understated the relevance of or the generality of the landlord control principle, but for our purposes it's helpful and relevant that it is about carving out premises, not incorporeal rights, premises from the railway hereditaments. And so it concerned, interestingly, premises at Victoria Station, and I'll take my lord through the speech of Lord Wright, which is possibly the less famous of the two speeches, both in the majority. In fact, actually, on the one point that there was a difference, Lord Wright was the full majority of that. But the reason I'm doing that is it's more, I'll show you what Lord Russell says very briefly afterwards, but Lord Wright's approach is very much orientated in the statutory provisions of the 1930 Railway Act. So if I could ask the court to pick up Lord Wright, Master of the Rolls speech, which starts at page 150, and he introduces the appeals arising under the 1930 Valuation for Railways Act. And I'm not sure I've shown the court that, but can I just, because I would just, it's in the vulnerable authorities, and it is helpful just to glance at that. So that's at page, if you wouldn't mind, I'm going to go back to Lord Wright is just
tab 6, is it?
It's tab 6. Thank you very much. And then it's the railway hereditament is defined at the foot of page 58. Railway hereditament means subject as herein provided any hereditament occupied for the purpose of the undertaking of a railway company, provided that no premises occupied as dwelling house, hotel, or place of public refreshment, or so let out as to be capable of separate assessing, shall be deemed to be or to form part of a railway hereditament. So some of the machinery that we're familiar with, the place of, for example, the hotel or place of public refreshment, and the concept of premises so let out as to be capable of separate assessment are common to Regulation 6 of the 2005 regulations and this provision. And this is the early predecessor of the provision that the treatments of advertising rights gets bolted onto in the 2005 regulations. So Lord Wright, back to his speech, starts at page 150. He introduces the Act at page 150, and he comments that the 151, the main purpose of the Act is to establish a single valuation of the railway undertaking as a whole in place of the practice of valuing each hereditament separately in the parish or rating area in which it's situated. And I would just observe that is what I would call the statutory purpose of amalgamation. It's the same purpose that's served by Section 53 of the 1988 Act, read together with the 2005 regulations.
Well, it's slightly different, isn't it? Because what used to happen was you had an overall valuation of a railway system. This is pre-nationalisation.
Yes.
And there was a formula for then dividing it between different parishes.
But the basic concept, rather than
but it started off as a single hereditament in the first place. There was no question of amalgamation. What this is all about is not splitting it up into parishes anymore. Anyway, I don't think it really goes to the heart of the case.
Okay. Well, my lord, my submission is it's a common purpose of a convenient way of dealing with the railway undertaking and identifying it, and that's although the valuation machinery might be different these days, that basic concept I respectfully suggest is common to both. Then moving on, page 152, the premises in Victoria Station are then identified, and just to not get lost in the detail of this, but we're concerned with the bank, we're concerned with bookstores and other premises, and then there's also what are called showcases, which the majority held weren't advertising because they weren't storing actual goods and just displaying actual goods. But in fact, Lord Russell dissented on that.
Well, they weren't advertising, I think they found.
They weren't.
Weren't.
Yeah. That's what I said.
They were more retailing.
Yeah, they were displaying goods. Yeah. This is the showcases. Yes, but yes. So what I said. So then, what Lord Wright does, just in terms of the structure of the judgment, at 154, he examines the agreements under which the premises at Victoria Station are held, and he does so in some detail. And I'm not going to go into the detail of that for present purposes, but because I'm looking at the basic approach at this stage. But that's what he does at 154 to 159. And then he returns at 159 to the Act, and if I could pick it up in my right by the lower hole punch, now it is true. So now it is true that the Southern Railway Company occupies the Victoria Station as a whole for the purpose of the undertaking, but it must be ascertained whether the same can be predicated of the different premises in question in the proceedings, and then he refers to the statutory powers to let out that were then vested in the Southern Railway Company. But I asked the court to note he starts with the proposition that the railway company is in occupation of the station as a whole, and then he examines how the Act works. And so if I pick it up again just below the first hole punch, the question relevant here is whether the premises were so let out as to be capable of separate assessment. And then he offers this observation: it is clear that something which otherwise would be a railway hereditament may cease to be such if it is so let out as to be capable of assessment. These words require careful definition. They refer, I think, both to the character and conditions of the letting and also to the purposes for which the premises are let. And then he goes on to say there's implied implicit reference to rules of law, etc. But that doesn't form part of his analysis. But if I go back to a question that my Lord Justice Holgate asked me before lunch, what does the word let out mean? And I said I will come to that. Well, this is, I would respectfully say, the best articulation of what the concept of let out so as to be capable of separate assessment means, is what is concerned with the character and conditions of the letting and also to the purposes for which the premises are let. And my submission is that that is essentially the same question as the concept of let out to someone other than the rateable occupier requires in an advertising case. Now, the answer might be very, very straightforward. It's a right to display an advert that's got no connection with the host premises. Well, that's an analysis of the character and conditions of the letting, and it meets the test of let out. But if there is a connection, that's relevant, I would respectfully say, to the character and conditions of the letting and to the purposes for which and here it says premises, but I say the concept of rights is bolted into the same provision in Regulation 6. And I say, in common, I think, with the observation made by Lord Justice Nugee, that it actually coherence rather suggests the concept of let out and let out so as to be capable of separate assessment are the same essential concept, albeit I accept they might need to be tailored depending to what the nature of the hereditament or putative hereditament concerned is there. So,
but it's the tailoring that I'm still having some difficulty in seeing where you're pinning your colours.
Well, so
you say it's not paramountcy as such. You say, well, now we've got to this case, look at what Lord Wright says, which is just in general terms that here are some factors we might want to look at. But if one is in the context of the hereditament we're concerned with,
yeah,
looking at the relationship between the railway as occupier of the physical space and the advertising right, what is the sufficiency of the connection, you say, to amount to a letting out? What is your test?
So the test is well, as my Lord put it, the essential question is the sufficiency of the separation.
No, I don't want to know what the question is. What's your answer to the question? What is it that puts it on the side of it being a letting out or not being a letting out?
But the reason I started with that premise was that was my case before the Upper Tribunal, and they said that wasn't the right question. But I say that is the essential question. And that's where I go back to paragraph 59 of my skeleton argument. That requires an evaluation of the extent, if any, of the connection between the advertisement and the host occupation, which brings in questions of purpose and also control.
So I just want to understand this. It's the extent of connection,
yes,
between the occupancy
and the advert
and
advertising right.
And the advertising right, and it brings into question, I think, two factors you identified. One is the purpose.
Whether there's a purposive link, in other words, whether the delivery of the advertisement is a fulfilment of the purposes of the host. So if you'll recall my cinema example from before lunch, and also I would say there's a railway example, because we've got a statutory concept of railway purposes. So here the display of adverts by JCD is the fulfilment, I say, of Network Rail's railway purpose. That's how I say this particular provision works. So that's a relevant part of the analysis, and the extent to which the advertising is controlled or regulated for the benefit of the host occupation. In the paradigm example, that is a nil return. In our example, that's the whole essence, or to use Lord Wright's words, the whole character and conditions of the agreement that gives rise to the right. It's controlling the adverts so that they further Network Rail's purposes, and they also always operate in a way that is subservient to the operational requirements of the railway.
In what way do they control? They're not vetting each individual advert.
No.
So in what way are they controlling the?
So my lord, I'll come to this, but the basic proposition is there's a case called ESSO, which deals with this, where often control, where you've got, and in fact in Cartronics, so where there's a mutual purpose, the concept of control needs to be quite carefully approached, because often the absence of a control is because you trust somebody to deliver something that's consistent with your purposes.
In Esso, the purpose of this petrol station was for Esso's business, because selling petrol is what Esso does. But how does advertising choose? How does that further the railway's purpose?
Well, again, when we discussed this before lunch, I made 2 points. I said, firstly, it was analogous to Cartronics, and my lord said it was a weaker connection. I understand that debate. But then I also say, in the context of this statutory scheme as a whole, it is clear that advertising is a railway purpose. So I rely upon that.
You rely on the words
Yes.
in Regulation 6.
Yes. And I rely on the history, which is that there was previously an exemption, and that bringing that within the definition was part of the continuity between the 1967 Act and the 1989 regulations.
So can I then just try and pin you down a bit further? You've identified 2 particular criteria, namely a purposive link, which must be sufficient or absent, and the extent to which there is control. What is your test in relation to either of those or both of those? What I really want to write down is,
Yes.
what do you say has to be fulfilled in order for it to be a letting out?
There has to be a sufficient separation.
What do you say is sufficient?
That there is an absence of a meaningful connection between the absence of a connection between the advertisement and the host use, so that it's analogous to the purpose for which this extra provision came into effect.
Sorry, just forgive me.
Sorry.
An absence of. Just say that again for me. Absence of any connection between the purpose of the occupier and the purpose of the advertiser. Is that what you're saying?
Yes, and or.
Wait a minute. Absence of any connection.
Well, I don't.
Is that?
Well, no.
I'm sorry to press you, but
No.
I'm anxious to know what
What
you say the test is.
It's the crux of the matter. Well, I mean, there is no case law that has.
I know, but we need to know what the test.
No, I'm trying.
What's your-
I'm trying very hard to assist the court.
What's your argument that it should that the test should be?
So the actual argument in terms of why the tribunal was wrong, I'll put it that way, is actually that you cannot exclude from consideration questions of purpose and control. So so it's a sharp point in terms of whether this tribunal went wrong, because they expressly did exclude those factors.
Right, but then
So then
I understand that. So then the question is,
yes,
what degree
Yeah.
of purpose or control link is or is not sufficient?
that's context dependent. That's
No, but what's the
context
test? What's the test?
Well, whether
Does it have to be substantial control? Does it have to be any control?
Well, I would suggest it's whether the advertising is obviously a separate use of land.
Separate from running a railway?
Yes.
Well, why do you say, I'm sorry, I've said this a couple of times, why do you say that advertising, shoes or anything else is not separate from running a railway? They seem to me to be two quite different activities with different markets and different purposes.
Well, the same, my lord, could be said of having a cash machine and running a retail premises. So it's possibly a more nuanced frame than that. But I come back to exactly the same.
So do you get assistance from Cartronics as to what makes something sufficiently separate?
Well, my lord, the direct answer to my lord's point is the statutory scheme read as a whole. It is I do rely very, very much as the centre of my argument that the relevant use of the railway here is Network Rail occupied both Victoria Station and Liverpool Street Station for railway purposes, and railway purposes for the purpose of the Rating Act includes the display of adverts. So the display of adverts is, under the statute, an expression of a railway purpose. That is the answer, and the reason why that seems odd, my lord, might be because the concessionary treatment that was apparent in the 1967 Act has been bolted into the central regulations in a way that might feel counterintuitive. But the rating scheme is full of things that feel counterintuitive but are deemed to be, and this is one of those things.
But that would mean that Section 64 calls to be interpreted differently in terms of what letting out means, as between, on the one hand, a railway, for whom there is a statutory definition of purposes including advertising, and, let us say, a supermarket, notwithstanding that it may be the case, I know you don't disagree, you don't agree, but that it may be the case that, in fact, for both of them, the purpose of advertising is simply generation of revenue.
So, my lord, there isn't a separate conceptual test. The separate conceptual test is always, is there a sufficient separation? There is a separate contextual application of that test for a railway, because there is a specific provision in the statutory scheme understood as a whole. So the railway gets a lot further than the supermarket because of that provision.
Because its statutory purposes include advertising.
Yes, and that's a contextual point that's sharp in this case and probably very blunt and non-existent.
Its statutory purposes are just a power which it can exercise in different ways, of course, across its estate. So the extent to which it happens to be a purpose in a particular context will depend on that property.
Well, my submission is that the Railway Act is what deals with station services. So the operation of a station is self-evidently a railway purpose. And then in the rating statute, you've got a rating-specific concept extension to that, which is that it includes the display of adverts.
I want to make sure I'm keeping up, because let out, you're taking us to case law which happens to be in the context of railway hereditaments, where the expression is let out so as to be capable, etc., etc. And you're saying the learning we get from examples on the railway can be read across to let out in section 64, subsection 2. I
say the words let out
have a similar
common heritage,
common meaning, effectively.
Well, my submission is
it's not. I don't understand.
My submission is that's right. My submission is that's right, albeit that what they mean is then going to be context dependent.
When you come to apply,
yes,
but
it's
helpful to try and identify the concepts to start off.
Essential separation.
Yes.
Essential separation is what I'm talking about. And I respect this. That's a really simple concept.
I mean, this line of argument happens to stem from Southern Railway, if correct, would apply to the interpretation of section 64(2) generally. But
in a context-dependent way.
Well, you come then to apply it.
And my submission is that would do that would cause no difficulty whatsoever, because in the paradigm case of a flank wall advert, there would be no evaluation to have. But life life occurs on a spectrum,
No.
and that's the essential problem with the tribunal's approach. Is they say that because this is a separate right, and because it's got its own rules for occupation, it exists in a quote self-contained concept. Well, may I finish?
Yes.
Sorry, but the essential point is, no, it doesn't. It exists in the real world where there are messy relationships between adverts and host occupation, and it exists in a rating statutory scheme where there is a bespoke approach to advertising at railways.
I entirely understand that point, but can I just try and finish off writing down what you say is the test for the sufficiency of the connection for purposes of letting out or absence of it. And I think in relation to the relative purpose of the occupier on the one hand and the advertiser on the other, you said for letting out there must be an absence of any connection between the occupier's purpose and the advertiser's purpose. At least that's what I've written down.
Yeah.
I think at one stage you might have said any meaningful.
Yeah, I mean,
but you put it at that end of the spectrum. If there's any meaningful coexistence between the advertiser's purpose and the railway's purpose, then that's it. It can't be let out.
well, no, I wouldn't say that.
Well, what is your case on the sufficiency?
No, so if there is, well, the case is that it's always going to be context dependent.
I know you say that, but what's the test?
So, well, the test is, I think the starting point question is there any meaningful connection? My lords might think in many retail cases that answer might be no. In every Frankwell case, it might be no. I say in the railway case, it's yes. What does that lead you to do? That leads you to, I would respectfully suggest, to wrestle with what is the character and conditions of the letting and the purposes for which the advert is being created. And that context comes in through the use of the words let out, even though in the paradigm cases there's obvious separation. But that gives you something rational to base the distinction on.
That doesn't answer my question. If a supermarket lets out the advertising rights on its flank wall, and the terms of the advertising contract is that you must spend 2%, 5%, 10%, 40% of your advertising revenue on advertisements which promulgate the benefits of the store, as opposed to other retailers. I mean, does 2% count? Does 5% count? Does 20% count? Does 70% count? What is? Does it have to be predominantly the same purpose? Does there have to be just some overlap in the purpose?
Well,
I mean, it matters, doesn't it?
It does, and yes, it's difficult, but this has never been thought about in the context of a nuanced connection, and there's bound to be a spectrum. I don't apologise.
Yes, but we would have to, if we accept your argument, we would have to propose a test, so that tribunals up and down the country could apply it. Well, it's not just enough for us to say you have regard to these relevant considerations.
Yeah, I understand that, my lord.
Can I put the same point a slightly different way? I'm looking at what Lord Wright said in some, top of page 551, 161 in the bundle.
Yes.
And he poses the question of whether the premises have been so carved out as to be capable of separate assessment, or whether they have, though let out, been so let out as still to leave them in the occupation of the railway companies. Now he's talking there about physical premises, bookstores and so on.
Yes.
So you can see in that context it's quite a simple question to pose. It may not be a simple question to answer, but conceptually it's quite a simple question. Who's occupying?
Yes.
Is it the rubber company or is it W.H. Smith?
Yes.
What's the equivalent question in our case?
Whether the advertising right in question has been so carved out of the railway hereditament to which it putatively belongs, so as to be capable of assessment, or whether on a true analysis it is controlled by and serving the purpose of the railway company.
So instead of the word occupation in that passage, we'd put
controlled by and or serving the purpose of.
Yeah, but aren't they?
Well, because it's a. I'm afraid.
Well,
I'm
I'm
sorry
going to come
say,
back to this. You've
I
got two limbs of your test, and I then understand what you say is the relationship between them.
Well,
is control enough
without
a common purpose?
It depends. Well, it depends. It does depend. So,
Depends on what?
well, if one looks at the way this is wrestled with, in, for example, Cardtronics, the absence of control didn't matter because there was a mutual purpose, and the delivery of the cash machine served the purposes of the rateable occupier.
So serving the purpose is enough.
Well, in that context, yes, but my case in this specific case is that there is a very strong indicator of control in clause 4.5 and 4.7. So, and there's also a very strong indication of purpose in the overall statutory scheme. So, quite
the ability to interrupt the display of advertisements at a particular site, which is what 4.5 and 4.7 do, and indeed the ability to terminate right on a particular site, doesn't mean you control what's being done on the site. It gives you an overriding right to bring it to an end temporarily or permanently. Lord Wright says, you know, the fact that you can terminate the bookstall's licence at a week's notice doesn't make any difference. As long as you're there, you're there. And so long as so long as JC Deco are advertising, they choose which adverts are put up. They price the adverts, and they're not doing it for Networks Rail's purposes. They're doing it for their own.
They're doing it for both.
Well, why are they doing it? In what way?
Because
I've asked this question before, I'm going to ask it again. Why does advertising something by JC, we've got some examples, photos, they're not advertising railway services. Why are they furthering Network Rail's purposes by selling advertising space to all and sundry? I don't understand.
So I've only got the two answers I've already given to that point, which is analogy with Cardtronics and...
No, in Cardtronics, the Supreme Court based their decision on the basis, as you've just said, that having an ATM in your store helps your business because people come to the store to get money out and spend money in the store. There's no equivalent that I can see.
May I go back to the start of the question, which was there are 3 points I'd like to make about control in relation to exactly what you put. So the thing that's different in this case, and this is where the Ludgate House decision helps, is that the control pursuant to clause 4.5 and 4.7 is controlled during the currency of the agreement rather than controlled by ending the agreement. So that's a different character of the agreement.
In this case?
In this case.
4.5 and
4.7. The second point I would make is the ESO insight, which is that when things are working well and you employ a competent subcontractor, the absence of day-to-day control is not an indicator of the absence of day-to-day intervention is not an indicator of a lack of control because you are trusting them to deliver on your purposes. So in ESO, it was Road Chef running the ESO.
They were running the petrol station, but as I've already said, they were running the petrol station selling ESO's petrol, which was ESO's purpose.
No, forgive me, and also selling lots of goods on their own account.
They were selling stuff for themselves as well,
yes.
but what they were mainly doing is what a petrol station does. They were selling petrol.
Well, what JC Deco are doing is they're selling advertising, which Network Rail, pursuant to the agreement, controls some of the content of, gets a significant revenue stream from during the course of it, and which furthers the railway purposes under the rating legislation, I say. So that's the second point, is if you like, an absence of intervention is not an absence of control. But the third point is, the bit that's actually crucial in the ESO world is when, if you like, the one purpose comes up against the other. The advertising comes up against the railway. And that's where clause 0.5 and clause 0.7 become critical, because the whole basis of the agreement, if we think about the character and conditions of the advertising agreement, the character and conditions of this advertising agreement is that the advertising must yield to the operational demands of the railway, whether that's closing down sites pursuant to the agreement, whether it's cutting across them to give travel information, or whether it's refusing access in the exercise of absolute discretion. all of that is, the whole character of it is that the advertising is in the middle of an operational railway and must always be subservient to it. So that is a very specific form of control, I say.
I understand that. Can I just, I'm sorry we're keeping detaining you.
Well, this is the heart of the matter.
But if we look at Lord Wright's
Yes.
test at the top of 551,
Yes.
and look at the second half of it, the converse, as
Yes.
it were, or whether they have, though let out, been so let out, as still to leave them in the occupation of the railway company.
Yes.
And if we try and substitute for that the hereditaments that we're concerned with, that is to say, advertising rights, as opposed to occupation of space, is the relevant converse of his test whether they have, although let out, whether the advertising rights, although let out, have been so let out as still to leave the railway company as having those advertising rights. Is that the right way of transposing that test into the context of advertising rights as opposed to occupation of land?
I think one would have to. I think for the purpose of the way that the hereditament is formed, you'd have to say, although, so forgive me, it's the.
Well, what I was suggesting is instead of being so let out as to leave them, that's the railway hereditaments, in the occupation of the railway company. We're now concerned whether the advertising rights, although let out, have been so let out as to still to leave them, that is to say, the advertising rights, with the railway company.
So the way I would frame it is the advertising rights, although granted, are subject to such controls that they have not been separated from the railway station.
Thank you. Separated in what sense?
Well, in the sense of let out. And what that concept means, but I do go back to, I would say, the tailored application. I can't do better than the tailored application of
purpose
Lord
and control.
Yes.
Can you help me on another point? Because you took, this all started off by looking at page 550 of the law report.
Yeah.
And there we see purpose and the conditions, etc., of the letting, which you relate to control. And then you moved off the next part. There is an implicit reference to rules of law which determine the position by their application. And he goes on to say, this is not to say that the rules, the determination in a particular precedent is determinative for these purposes, but what we're looking for are the principles we get from the case law. And then that takes us through, he says at the bottom rather dishearteningly, though it becomes necessary for the court to attempt to serve with the whole of the existing authority, etc., etc. But this seems to be a drum roll leading up to what happens in the rest of the judgment when he reviews Holywell Union, for example, on page 552. And so we go through all the case law. This case law is basically dealing with paramountcy of occupation, isn't it?
Yeah, well, that's the context.
That's the context.
Yeah. No, I absolutely accept that. And that's why I say, but
this is the analogy.
The case law is, but what he says.
I mean, is this a fair way of understanding your case, that you don't rely on paramountcy of occupation? Because if you were to, the problem with that is when dealing with an incident of property which is not capable of occupation. Is that the point?
That's.
So you said this is why the analogy is used.
Yes. Because
we move away from occupation and we use purpose and control in your paragraph 59 of your skeleton.
Yes.
To describe either the sufficiency or the insufficiency of the link.
Yeah, exactly.
So happens that purpose and control are cardinal features of paramountcy of occupation.
Yes. But
I'm
so
a bit
too.
confused.
The basic point the ingredients of the argument are, this is Lord Wright thinking about a provision that is worded very similar to Regulation 6 from 2005, but onto which Parliament.
But forgive me, the context is, you're absolutely right, the wording is very similar, But the context is it's being applied to properties which are capable of occupation.
Yes, and
We
Parliament...
don't know what the House of Lords would have said if they were dealing instead with a property or a right incapable of occupation.
There's no authority on this point anywhere. That doesn't mean that the submission is wrong. It means it hasn't come before the
No,
courts
but
in
it
the way
begs.
that it's come.
I understand that, and it's a fair point. But it begs the question: is it a relevant analogy or a sufficiently close analogy?
Well, my lord, I say yes for the following reasons. Firstly, the concept of let out has got a pedigree and a heritage in rating. Secondly, if you look at the structure of what Lord Wright is doing here, he's looking at the statutory terms, he's offering reflections on what the concept of let out means in this context, and that's where the character and conditions of letting. That's a perfectly apt concept to apply to an advertising right where there's a real question about its distinctness from the host occupation. That won't be any of the cases that have previously come before the court, because there's obviously been a separation, but I say it is this case, and it may be other cases. Lord Wright, the premise before we went to all these cases was that Lord Wright does say, I don't think that these words mean an entirely fresh departure is to be made from the principles of rating. So he's reading the railway provision in continuity with what went before. Now, if we think about what Parliament's done to create the issue that's before this court, is it has just simply added into this very provision the concept of rights, so let out as to be capable of separate assessment. Now, that doesn't allow this court to pretend that it's dealing with competing occupations, because that would misunderstand the nature of the rights. But I say it does, as a matter of construction, strongly support the idea that some of those same concepts are relevant and need to be applied and tailored to the context. Now, below, with respect to the Upper Tribunal, they created a false dichotomy between paramountcy and self-containment. My case was and is pitched in the middle ground of those two propositions.
But why?
It's about a tailored application.
Sorry to interrupt, but why? If the analogy is a sound one at all,
Yes.
then why don't we simply adopt paramountcy? So if the analogy is a sound one, why isn't the test whether the paramount purposes are those of the railway rather than the advertiser, and whether the paramount control is that of the railway rather than the advertiser?
Well, but those two concepts, I say, remain relevant, but they have to be tailored to recognise the essential features of the advertising right, which doesn't allow for anybody, or doesn't require anybody to be in occupation.
Yeah, well, we've got that. We really have got.
Yeah, no. Well,
but I mean, I was going to ask a similar question to my lord, because you talked about a spectrum.
yes.
It's a fact and degree type question.
Yes.
You have a range of situations.
Yeah.
If the two cardinal indicators of purpose and control, I mean, picking up my lord's question, there can be a degree of control. And you could ask the question, well, does A have more control for the purposes of advertising than B?
Yes.
But presumably you wouldn't ask the question, who has more control for the purposes of operating a railway station? Because that's not relevant. We're dealing with a right to advertise.
But how does the right, it is relevant to say, how does the putative right to advertise related its expression to the host use? In other words, if it's subservient to that, then it's not separated from that, and it's not a separate hereditaments.
Yes, but we're dealing, as you rightly say, with an advertising right, and we have to decide whether that's been let to a third party, where both the grantor and the grantee share, you would say, in that purpose. Am I right so far?
Yes.
Understand? Yeah. Okay.
Yes.
So there's a legal tug of war going on between the two, and you're borrowing these concepts from Southern Railway. One concept you get from Southern Railway is that in looking at the relativities, if you want to use another word, between these two parties, you should focus on the item that you're rating.
Yes.
which is the advertising
Yes.
right. And
Well,
so far, I think.
Well, aren't you deciding whether to rate it rather than rating it?
Yes, but you're deciding whether to carve it out.
Yes.
And in carving out, which is what's going on in Southern Railway, they focus on the W.H. Smith kiosk, not on the station.
But,
Is that,
well,
is that appropriate here?
No, it's moved on from that though, because that's correct in Lord Russell's speech, but that was course corrected in Cardtronics,
Okay.
where you had to engage with the relationship of the putative small site with the overall. So the relevant question.
Yes,
in
but
our
what?
case,
Okay, but forgive me. I understand that in terms of looking at the areas, for example,
Yes.
involved and how they're used. But coming back to your point about purpose,
Yes.
the relevant purpose is advertising,
Well, no, I don't accept that. I say there are two relevant
which happens to be a railway purpose as well.
Well,
But
that's true.
But can we forget railways for a moment?
Okay.
Because we have to think about how to
Yeah.
interpret Section 64(2) generally.
Yes.
So if you're interpreting it generally, the relevant purpose is advertising, isn't it?
I don't accept that. I would say the relevant inquiry is the extent or otherwise of a relationship between the advertising and whatever the host's occupation is, because that's what I say the focus of Section 64(2) is. It's let out is the word, but let out begs the question from what? It's let out from the host occupation. And my very simple proposition is there are cases where you have to understand what the host occupation is and the extent to which it relates to the advertising. And what I'm complaining about in this court is the total exclusion of that from relevance, which is, I respectfully say, a mistake of law. Because it's inherent,
let's
inherent in
assuming
let
you're
out.
right about that, we still have to work out what the right approach is.
Well, I appreciate that.
Well, that's
Sorry for the position
that's
you're
one
in.
way of actually. Forgive me. That's one way of testing whether the tribunal was wrong.
Well, can we look at let's test it by reference to what they actually say in paragraph 58, because that's the crux of where they narrow the submissions. So I say that this doesn't form any coherent line. So if I look at paragraph page 90 of the Upper Tribunal's decision, the same flexible approach ought logically to be applied to the question of whether land or a right has been let out. The words do not denote a letting or grant in a technical or proprietary sense, but some transfer or conferral of the right in question by the person entitled to it to some other person to use for their purposes. Now, pausing there, they have thought about the purposes of the advertiser and they have excluded the purposes of the host. That, to my submission, is that does not make sense as a distinction, because they are shutting their mind there to the relevance which exists on the facts of this case, I say, of the advertising furthering. So that's not a coherent distinction. Carrying on, practicality might suggest there's some degree of longevity or exclusivity. Well, longevity is an equivalent of the four characteristics of rateable occupation include whether it's two transients. Well, longevity and transients, well, they're there. So doesn't that rather show that as soon as you start thinking about what the relevant criteria might be in a boundary situation, you cannot hermetically seal that process from the type of factors that have been influential in paramountcy cases? It doesn't mean you pretend it's paramountcy, but it does mean it's a mistake to ignore that.
Can I just come back to whether it is or it isn't paramountcy? And for these purposes,
yeah.
We're assuming that there is a relevant analogy to be drawn between occupation of space and advertising rights. But if, when we come to advertising rights, the starting point is these are valuable rights. The purpose of the legislation is that they should be subject to business rates. They will be have business rates charged on them in the hands of the occupier if they're reserved or not let out at all. If they are let out, whatever that means, they will be rateable and charged in the hands of the advertiser. Now, if one's then looking at the question, how do we decide whether they be let out or not for the purposes of deciding who should be subject to what, for the moment, let us assume simplistically, which may be the case for someone who isn't a railway, simplistically is exactly the same amount of money? Why would it not be sensible to apply a paramountcy test by reference to purpose or control of saying, have these rights been given to use a neutral term, the advertiser for the advertiser's predominant purposes, or with the advertiser having predominant control, or on the other hand, have they only been alienated in a way that the occupier has retained the predominant interest in those advertising rights? If it's simply a question of who's to be charged for the value of those rights, isn't it sensible to apply a paramountcy test?
Tailored for the paramountcy, I'd say yes.
Well, why tailored?
Well, I think you do need to tailor it because you need to keep in account that you're not looking for competing occupations, you're looking at the carving out of a specific right from an occupation, and that is a tailoring. But I entirely adopt the point that you're putting to me as a point that is central to my case, and the reason, just to bring it back to the purpose, the reason why it is sensible is that we only got the advertising right as a separate concept because there was an inequity that otherwise it was landing on people that had nothing to do with the advertising. So you've got a spectrum of cases, and there are a whole load of cases where there is a functional link between the advertising and the host occupation, and at that point the question is, what's the most convenient way of dealing with it?
Well, it was more than that, was it? It's also that the value of the advertising rights should be rated in the hands of the occupier if the occupier is enjoying them, as part of the additional value, as it were, of the occupation of the premises. Was that not part of the early history?
The early Section 4 did that, and then the iniquity was that it did that, and so the poor chap living in his dwelling house that had a advert on his flat wall was charged extra and got no benefit, and that was the iniquity that they were motivated to enact the advertising right. So my proposition is that the function of the words "let out" are to convey something that's akin to that purpose of sufficient separation, which gets you inevitably, if that's
I understand
right,
that, but that's the other side of the coin of reservation, which is that they are to be rated and paid for in the hands of the occupier.
Well, reservation is where they've been kept. They've been kept rather than added on.
Kept rather than alienated.
Yes, but it's the same. I would suggest it's as I say in the skeleton, separation is the essence of both concepts of reservation and let out. And I say separation is the essence of the purpose, and I say separation is the essence of the word used, and I say separation is the essence of the concept of the words used in the case law, and I say separation is the essence of the way it's explained in all the cases as well.
What is wrong with the first sentence of paragraph 58, which talks to some transfer of question by the person entitled to it, so that's the railway company, to some other person to use for their own purposes. That is a separation from the railway company's enjoyment of the land by giving it to someone else to use for them to enjoy. So why do you criticise that as a statement?
Because what respectively the tribunal has done is that they've looked at one side of a two-sided equation.
Well, I understand that, but it's for their own purposes. Is effectively saying it's not for the railway company's purposes; it's for the advertiser's purposes. And
forgive me, it doesn't say that. That's exactly what it doesn't say. That's exactly what it doesn't
but
say.
If it did say that, by the person entitled to it, some other person to use exclusively for their own purposes rather than for the purposes of the railway company.
Then I might be here on my ground 3 and say that's a misapplication of the relevant law, but I wouldn't be saying they've excluded from consideration a relevant consideration, which is what I am saying. So what they've done there...
Okay, well then let me ask you this, because they go on and say in 61, well, suppose we were to apply a paramountcy test. We don't think Network Rail would be in the position.
I've got to make good that as a separate stage of the argument.
Okay.
What-
Well, I will
I'll
still
get my
ask you
schedule on
questions, but I would like to hear in what way Network Rail is in paramount control of the advertising rights, because at the moment what they say in 61 to 62 seems to be the answer to that.
Well, can I try to? I will come to that in just a moment. I'm very conscious of time. May I? So I haven't shown you Lord Russell in Southern Railway. Can I just give a reference?
Yes,
to,
we should let you get on because we're
I-
using up a lot of your
I
time.
obviously need to get to ground three, particularly in the light of what my Lord Justice Nugee said to me. But so I'm going to canter through and get to ground three and spend some time.
Yep.
So may I just say that Lord Russell deals with railway provisions briefly at page 137. He then, in a very kind of famous passage, deals with general observations about rateable occupation at 139, and he treats a lodger as exceptional at 140, and he dissents on the showcases at 145. I say all of that just by way of context, but I don't need to take time on that. The passage of this that I wanted to show the court was the way that Lord Wright framed the issue. I'm then going to just do this very quickly by reference to my skeleton, because I'm very mindful of time. I want to just tell the court what I say about ground three, because I haven't had a chance to develop those points yet. So if I do this by reference to my skeleton, there's also the case of case, which is a 1972 discussion of let out in a railway context, which is concerned with a railway staff association, and the relevant part of that is the speech of the judgment of Lord Justice Buckley, and he ventures some opinions and about what he thinks is an odd expression let out. That's in a corporeal context, so it's again its premises should they be carved out of the railway. He says there's little authority on the meaning of let out, and importantly at page 214 he articulates that by reference to effectively the essence is that you permitted some other body to occupy it for purposes other than the purposes of the ratepayer. So it's a separation of purpose, which Lord Buckley says is the essence. Lord Justice Buckley says is the essence of the concept of let out. Now that idea is like orthodox in the paramountcy, and that basic idea is developed in the case law on paramountcy.
Is this an example of the paramountcy principle being applied?
Well, I think it definitely is in case, and so it doesn't take us analytically any further than Lord Wright. It's just an application. It's a fact-specific application.
But interestingly, the club was a club for railwaymen.
Yes.
I would have thought that was a great deal more closely connected with the business of the railway company and running the British Railways Board and running railways. But it's still treated as separate purposes of the person to whom it's being lent.
Well, it was, which was a fact specific, but there wasn't, and I'm sorry to come back to it, but there wasn't a provision deeming the provision of the club to railmen and to be a railway purpose. So may I? But all of these points are fact specific. Now, ground three is a fact specific point, but grounds 1 and 2 are in principle points, and the principal point is that these considerations shouldn't be excluded. Then there's the Supreme Court decision in Cardtronics, which arises in the context of ATMs at retail stores, and I haven't got time to take the court carefully through that.
Well, I think we've all read it, so you can
The
take us to the bits
references
you
are
want.
in the skeleton, so thank you, 28 to 30. But the gist of that, I would respectfully say, is that it limits Southern Railway as a bit more contextual. It elevates the concept of the landlord control concept as being more important.
Where does it do that?
So, in particular, paragraph 47 disagrees with Mr Moorehead's formulation that this in 46 and 47 that this is a
Well, I mean,
exception.
Mr Moorehead tried to say it was an anomaly in the context of the lodger case.
Yes, and that was a familiar principle,
Yeah.
and it was a general application. So, in the way that the issues are framed at 14 and 15, the idea is that Peschel's concept in Halkin, where a person already in possession is given to another.
I mean, it's interesting, if you look at the end of 47,
Yes.
Lord Wright, if we're relying on him, referred to that example without suggesting it was exceptional. He said the landlord occupies his premises and uses them for his business of keeping lodgers.
Yes.
So again, it becomes very important to define what area you're talking about,
Yes.
and the purpose applicable to that area.
And my submission is, here we are talking about the station,
Yeah.
and here the purpose is the running of a railway station, which is a station service under the Railway Act of 1993, and within rating, the display of adverts is bolted onto that station
Well,
service.
undoubtedly, you would be talking about the station and its purpose if you were looking at a corporeal right. But we're not.
No, but what we're looking at whether there is an incorporeal right, and the only way that we can.
Well, there is. We know there is the only question is it let out?
Forgive me. No. Well, we know. I think
Whatever right is being given to Deco is not like a piece of land. It's like an easement.
So what I meant was whether there's an advertising right under Section 64(2), which requires engagement with the concept of let out, which I say brings you inextricably to the relationship of the advert with the host. I think
speaking for myself, it would help for me to understand. You say Cartronics has changed our understanding of Southern Railway. I understand that. I need to grasp as to how you apply that to an advertising right, because I can see how anyone can apply this to properties in general.
Yeah.
But how is this nuance in Cartronics to be applied to an advertising right?
So the critical nuance, I respectfully say, is that the classic approach of the Southern Railway was that, relying on the passage from Lord Russell, was that you zoom in only on the putative hereditaments and you ask and answer the relevant questions by reference to the putative hereditament. So in that case, W.H. Smith, in our case, we would say the advertising right. The critical insight is that is too narrow an approach in a circumstance where the service in the case of Cartronics, or I say the advert in the case of this, is there to do something for the host occupier, and in that context, yes, you have to take account of that. And so, if the exchange I had with Lord Justice Nugee, can I say that the advert is the advertising right is for a railway purpose, just looking at the advert? Well, that's harder. But if I'm actually looking at the relation, what the advert does, which is, I would say, an expression of the fulfilment of Network Rail's railway purpose, having regard to the expanded definition, that is a relevant factor. It's back to paragraph 59 of my skeleton. The purpose and control are relevant. The vices that they've been excluded. And my lord, I hope that answers the question. That Cartronics, I think, moves the dial on taking account of the wider objectives of the landlord in understanding, if you like, whether there's been a carving out or a separation of the separate hereditament from that which, looking literally at Lord Russell and certain passages of Lord Russell alone would do. So if I can draw the threads together, I say on this big point that let out does have a recognised meaning in the rating context. In the railway context, it's been looked at in terms of carving out premises for a railway hereditament. That's the provision into which Parliament in the 88 Act, read together with the central regulations, drops the question of advertising at railway stations. And in that context, I say it requires an examination of the character and conditions of the letting, the purposes of the host, see Cartronics, and the relationship between that and the putative advertising hereditament, and the contractual arrangements and what they tell us about who's in control of the display of the adverts, having regard to that wider relationship. And essentially, the central mistakes of the Upper Tribunal were to exclude those questions as immaterial and to say that the inquiry didn't even arise because the advert was taken out before you get to Reg 6. Both of those are errors of approach, I say. I haven't shown the court. I haven't shown the court Ludgate House, which is important for ground 3. May I do that very briefly? So that is a relatively recent Court of Appeal decision. It's behind tab 28, and we deal with it in our skeleton at paragraph 32. But this is the most recent higher court decision. The context is very different. It's a building guarded by property guardians, but the reason it's potentially of assistance is it shows the seminal importance of understanding the conditions of the letting, and it's the lead judgment is given by Lord Justice Lewison, and it's after Cardtronics. If I could pick it up for my purposes, please, at paragraph 42. So he's just referring to paragraph 42 is on page 438, and he is just referring to the landlord control principle, and then he says this at 43. Having regard to early observations, I find it difficult to suppose that Lord Russell was saying contractual rights and obligations were irrelevant if they had not been exercised. On the contrary, in my opinion, he considered the relevant question was whether, if exercised, those rights would interfere with the occupant's enjoyment of the premises. And then paragraph 44 makes the same point. It seems to be the critical point was the terms on which the putative hereditament was held. In paragraph 49, he endorses the decision, or a passage in paragraph 81 of the decision of the Upper Tribunal in Esso, which is helpfully set out there at paragraph 49. And it's about seeing the essential factual basis as a critical part of the facts, of the factual background. The nature and attributes of the title to occupy, which the documents of the title is certainly very relevant. An essential fact of occupation is the relative position of the parties and the rights under which each party occupies. Now, although that's expressed in terms of occupy, its essential point is you've got to understand the conditions of the agreement. Paragraph 59, he analysed the seminal rates for occupation case of Lang as being involving turning on an examination of the contractual relations. That's paragraph 59, and then he came to apply this between paragraph 77 and 81. And if I could just draw attention to 77, paragraph 104, the Upper Tribunal said there was no evidence from which the general control of Ludgate House of the individual rooms could be concerned. They seem to have been looking for the exercise of the rights which Ludgate House held, but in my judgment they were wrong to confine themselves to the actual exercise of the rights, rather than assessing what effect the exercise would have, what effect the exercise would have if exercised. And then to similar effect, he talks about the relocation provision at paragraph 79, and at paragraph 81, picking it up, it's difficult to think of a greater retention of general control over the premises than the ability to require the occupier to vacate the premises without notice. Mr Fawcett went on to argue that even so, the tenant at will is in rateable occupation. That is so, but in my judgment, the analogy is a false one. First, whilst the tenant at will endures, the tenant at will has exclusive possession. And secondly, we are concerned with the anterior question, whether the terms of occupation of a guardian was entitled to exclusive occupation of a particular room in the first place. And secondly, if the tenancy at will is terminated, the relationship between the landlord and the tenant itself is terminated. By contrast, a right to require the guardian to move rooms is a right exercisable under the terms of the agreement whilst the agreement remains in force. So the gist of that is you can look carefully at what the relevant rights tell you, whether or not they are exercised, and place particular relevance on what can be done pursuant to the contract when it is in force, as opposed to when it is terminated. And I don't have time to go there, but Esso is set out in paragraph 31 of the skeleton. Now, can I just draw the grounds together as briefly as I can? don't know if the court wants to hear very briefly my formulation of ground 1 and 2 and 4. Well, 1 and 2 I've probably covered a lot, but just essentially the tribunal took an erroneous approach to the concept of let out to someone other than the occupier of the land, because they essentially treated the fact that there was a separate kind of hereditament with deeming rules for occupation as determinative. But that begged the question of what let out someone other than the occupier means in a case where there is a link between the advertising and that there's control under the contract as to how the advertising works. Critically, that it must yield to the operational requirements of the railway. We say they were wrong to turn their back on an available fund of knowledge from railway cases, rather than adapting them as necessary to any special factors which applied in relation to advertising rights. And we say that what their paragraph 58 shows is that you necessarily have to import some of the concepts that have been discussed in the paramountcy cases for deciding what the boundaries are, but they then didn't draw the line in a logical place by explicitly excluding the relationship with the host purpose and an evaluation of the control exercised under the agreement. And I say, as best I can, that the right approach is that set out in paragraph 59 of our skeleton, in the context where the provisions show that this came into existence in the archetypal Frankwell case, and the concept of let out must mean something where there are the relevant relationships and relevant control is exercised. So you need to have the function of the concept of let out is actually putting some constraints around defining what counts as an advertising right, and that's the task the tribunal said didn't arise, and then approached it, if you like, from scratch in a way that I say isn't coherent or consistent with the authorities. So that's ground 1. Ground 2 is that in paragraph 48, the reasoning is absolutely clear on the basis you never get to regulation 6. The local advert is taken out from the application of regulation 6. I say that's inconsistent with a proper understanding of the history. It doesn't make sense in the context of the way the advertising rights have been added on to an established carve-out from railway provisions. The language of carved out, which they said was inappropriate, is the very language used by Lord Wright in the passage from Southern Railway that I've said the only way to think about Regulation 6 coherently is that it is in play. You approach it by starting with the occupation of the station as a whole, and then you ask, are the conditions satisfied? Railway purpose is definitely satisfied because of the deeming provision in relation to advertisements, and it then turns on whether it's an accepted hereditament, which turns on whether it's rights so let out as to be capable of separate assessment. But the whole rationale of the tribunal's reasoning was that that's a different concept from let out for the purpose of section 64.2. I say that doesn't work generally, see ground 1, but it certainly doesn't work particularly in relation to the central list. It proceeds on a fundamental misunderstanding of how rights were added into that provision as a way of implementing what was a more generous provision under the General Rate Act, where the advertising right goes in the primary legislation and the carve-out provision for the station goes into secondary legislation. The only coherent way is to read those together, and that's exactly what the tribunal didn't do in paragraph 48 of the decision. May I then spend a few moments on ground 3, which is the factual ground. As per Ludgate House in the Court of Appeal, the established approach focuses on what the agreement tells us about the contractual rights of the party under the contract during the subsistence of the agreement, whether or not they've been exercised. The tribunal summary in paragraph 61 to 62 simply does not fit within this established approach. We say the critical provisions of paragraphs 4.5 and 4.7 of the agreement, that's the permanent interference in Network Rail's absolute discretion and the temporary interference at any time if Network Rail considers it's necessary or desirable in connection with the operation of Network Rail's undertaking. The tribunal approached this as akin to a right of termination, but that overlooks the key point that these are rights which are conferred under the agreement and which are exercised during the currency of the agreement. So that was, we say, a misunderstanding, a misapplication of Ludgate House, and in any event, an erroneous approach. The temporary rights, they said, were analogous to the closure of the station. I respectfully submit that that's not a good analogy. These are much wider than the general power. They can be exercised whenever Network Rail finds it desirable. The tribunal then relied on the fact that the rights have been, quote, used infrequently. Well, that's an incomplete and, with respect, illogical analysis. First of all, per Ludgate House, the real question is, what do these rights tell us about the position of the parties during the subsistence of the contract? It tells us that Network Rail can override the advertising if it considers it needs to for the operational basis of the railway. So the equivalent would be, like in Southern Railway, if the bookstall was requisitioned, the books were cleared out and it was used to distribute timetables. That would be the functional equivalent. It is a overriding of it. It's not a restriction of access. It is an overriding of it. It is of a different nature and character. But in any event, it's completely flawed to focus only on the particular rights at issue. This is a test case. It's accidental which particular rights have been chosen to come before court. The real structural question is, what's the overall evidence of the exercise of rights? So my primary submission is, it's what does the agreement tell us? But if you're going to get into how they're exercised, there is no logic whatsoever for restricting the analysis to the particular rights in question, as opposed to the general evidence of the way in which actually there was routine overriding of digital advertising rights to give transport information across the portfolio of sites. Now, unfortunately, the tribunal didn't grapple with the oral evidence that it heard. It did hear oral evidence from 2 witnesses. It didn't make findings. It didn't make any detailed findings. My primary submission to this court is, because the right approach is to construe the agreement, I say you should construe the agreement, and you should construe the agreement in a way that has regard to what the rights tell us if they are exercised. But if, contrary to that, as a secondary, you need to get into the evidence about whether these rights have been exercised, unfortunately this tribunal hasn't given this court enough. And if we're in that territory, then the answer might be that it needs to be remitted for proper.
But you, as I understand it, you rely on the passages you've identified in your skeleton argument from Miss Jasmine, I've forgotten her second half.
Yeah,
I mean, that's the evidence you say would make a difference and ought to have been taken into account.
Well, it was her. Well, there were no findings about practical operation other than the one that says, well, there's been limited exercise in relation to this particular right. There's no findings in relation to the rights more generally, and that was canvassed in evidence. It wasn't addressed, and I say it's incorrect. My primary submission is it should all be about what the agreements confer, even if not.
I understand that. If we get to this stage,
yes,
the evidence you say, which we ought to take account of in order to either to decide the question ourselves or remit it, is that you've identified in your skeleton.
We have identified our evidence. It is there, but the health warning, my lord, is that
that's not been the subject matter for any findings.
No, those witnesses were called. They were asked questions by the tribunal. They were asked questions by my learned friend Miss Ward. There's no findings. There's a complete absence of findings. And we've got 2 short paragraphs on the approach. Respectfully, the case that was put to them deserved a much more thorough evaluation.
I had thought that the witness evidence you had identified in your skeleton had not come from someone who was called at the hearing.
There were 2 witnesses called.
Yes.
Miss Jarman Smith and Mr Wood. They were both called.
They were both called.
They were both called.
Thank you.
And then the tribunal effectively tries to draw some analogies with the case law in paragraph 62. May I just briefly on those? I say access to premises is absolutely not the same as preventing the display of advertisements. That's not a sound analogy. conduct based on disqualification is not analogous to interference with advertising rights, or for that matter, having an absolute right of control to the premises in, for example, clause 19.2. The tribunal draw on the case of case, where they say the right to use the premises in case was relevant in an analogy. Well, my submission is that the relevant analogy there would be Network Rail's allocation under contract 18, which was no part of our case. We rely on the ability to override, if you like, in the absolute discretion of Network Rail, and if it feels it's desirable for operational purposes. That's very different to what happened in case. And just for your reference, at page 207 of the bundle, there were 2 instances of closures of different branches in case due to either misconduct or operational reasons. Well, that's an entirely different situation, because that is terminating the premises, and there were only 2 instances. That is not the ongoing control during the operation of the agreement, which is the focus of our case, of our submissions in this case. So what we say a correct application of the principle should look like is that the adverts serve Network Rail's purposes. I won't revisit the discussion we've had about that. That the mere fact of exclusivity simply reflects the expertise of JCDecaux, and it causes no difficulty in a case where the expertise is deployed to deliver a service which furthers the occupational purposes of the station for railway purposes, similar to Cardtronics, similar to, I would respectfully suggest, ESSO as well. But in Cardtronics, the references in our skeleton argument, the ATM provider had exclusive rights to provide ATMs, but that was held not to be not to override the considerations of, in that case, whether the landlord was in control. So I say the proper evaluation of the contract shows that the adverts are always kept subservient to the operational needs of the station. There's a right to interfere temporarily and permanently, rights to restrict access in absolute discretion. All of those rights are exercised and operational during the subsistence of the agreement, and in essence, the essential structure of the agreement is such that the advertising must yield to the operational requirements of the railway when it needs to, and that is a critical feature or character of the agreement which is relevant to the questions, and which is not, I respectfully say, assessed in the tribunal's main analysis or sufficiently reflected in its factual conclusions. So the primary answer is, as I've said, the answer is clear on a proper application of the law, as most recently stated in London House. But my fallback submission is that if you do need to get into practicalities, you should approach with very considerable caution section J of the Valuation Officer's skeleton argument, which seeks to rerun a factual case in this court, which is not underpinned by sufficient findings from the Upper Tribunal. And then very finally, I do apologise that I've overrun, the ground fall relates to paragraph 65 of the Upper Tribunal's decision. They approached it on the clear basis that the submissions that were made about the practicalities of this were irrelevant. And I say that's wrong at 4 levels. The first level is it's out of kilter with the established approach to statutory interpretation that we speak in paragraph 98 of our skeleton argument. Secondly, I say it's inconsistent with the approach in rating taken by Lord Carnworth in the Iceland case in the Supreme Court at paragraph 36, where the established practice over time was something that could cast light on the questions in that case. And so I respectfully say, in the particular context of rating, how things have worked practically is a relevant factor to think about in terms of the construction rather than to shut out. Thirdly, in any event, it's manifestly inconsistent with the statutory purpose of amalgamation to disregard the consequences for the sensible practical operation of the separate listing of several hundred separate advertising rights at these 2 stations and many thousands across the portfolio of stations. There's an obvious inconvenience there which directly contradicts with the statutory purpose of amalgamation. So I say that is relevant because it's an indication, rubs up directly against the rationale for the provision in section 53 as the enabling act and the central risk regulations as a whole, which are looking at the convenience of amalgamation. I also say, and I don't that the approach does lead to strange and unexpected anomalies, and I haven't got time and I won't raise specific examples other than to say this. The vice of this point is the tribunal's approach severs any connection with purposes, and that I suggest will lead to an approach that's out of step with the rest of rating law. So I gave the example of the cinema earlier, and the idea behind that example is that there is an ultra functional connection between the adverse and the occupation, but on the tribunal's analysis that is immaterial. My submission is that can't be right. Just thinking about the decided case law, we know that the landlord control principle applies to ATMs, and that generally speaking ATMs are part of the retail offer on the premises post Cartronics in the Supreme Court. But if there is a sign advertising the ATM, on this analysis the very close functional connection is irrelevant, and so the consequence of that would be that the sign would go in the rating list. That is, I would respectfully say, a direct consequence of a purist approach to what let out means. That shuts out the necessary context, and I think I respectfully say that will lead to anomalies. And the other example I just invite the court to reflect on is in the Esso case, there was the petrol filling station and then there was the motorway services building. The motorway service building, as one might be familiar with, you go in there, it's a service station and there's a load of franchises, but that's a single hereditament. But on their analysis, depending on precisely how the rights are conferred, any rights of signage might well be separate hereditaments because you're severing any functional inquiry. So this will lead, I respectfully say, deciding this as yet undecided point in a way that shuts out the relevance of an adapted version of the way the law generally works, will lead, I would respectfully say, to significant anomalies, which will potentially lead to the atomisation of advertising in the local list in a whole host of circumstances where there is actually potentially a close connection with the host use, and that, I say, is based on a misunderstanding of the concepts inherent in the language of let out, which I say means sufficiently separated in all the circumstances so as not to exclude a purposive inquiry and not to exclude the examination control. And the central complaint is the tribunal effectively got that fundamentally wrong and misunderstood the central list and the local list. I apologise that I've exceeded my time limit, but unless I can help you.
We've had some interruptions. Thank you. Yes, Ms. Ward.
Well, it's nice to have a moment to reorganise. My lords, the division of labour on this side of the bench is that I'm going to address grounds 1 and 2, so the statutory interpretation points, both the primary and the secondary. My learned friend Mr Flanagan is going to take ground 3, so dealing with the agreement and the factual points. We haven't quite decided on the division of labour on ground 4. It may well be, given where we are now, that I take it quite shortly in my submissions tomorrow morning, but we'll certainly confirm that before we start again tomorrow morning. So on grounds 1 and 2, my point really is very short. And that the legislation is to be read in accordance with the ordinary meaning of the words to use, and that it means what it says. I'm afraid, my speaking is I'm not sure I need to show you the legislation again, but I think actually, given where we've got to, it may be helpful just to turn it up very quickly. before I do that, just to give you a roadmap of the submissions, point one will be to note the terms of legislation, what we say about them, and the very limited, as my own friend Mr Kalinsky identified, case law that exists in relation to that legislation. Secondly, an analysis of the legislative history, which we say shows quite clearly that to get to where Mr Kalinsky wants you to get, you need a carve-out of the kind that was in section 28.6 of the 1967 Act, and that simply no longer exists and has not existed since the 1988 Act was brought into force. And then thirdly, to address a number of discrete points that were made in the course of oral argument. So dealing firstly then with what the legislation says, starting, if we may, with section 64 in page 14 of the authorities bundle behind tab 1. So you have by section 64.1 the hereditament being anything which by virtue of the definition of hereditament in the previous act would have been a hereditament. And then 64.2, in addition, a right being a hereditament if it's a right to use any land for the purpose of exhibiting advertisements. And relevantly to this case, that right is let out or reserved to any person other than the occupier of the land. So pausing on the words there, firstly, this is, as the Upper Tribunal correctly identified, separate to the consideration under section 115, pursuant to section 115, of all of the old case law, whether or not a hereditament exists, applying the test of rateable occupation under the John Lang case, which my own friend has referred to, which we'll see later in the authorities. This is an additional type of hereditament, and it has its own rules. It is a hereditament that consists of a right to use any land for the purpose of exhibiting advertisements. Now, such a right, of course, exists generally in the owner of the land, the owner or the occupier of the land, subject to perhaps any statutory planning constraints, etc. But it's a right that can exist in relation to land, and it's a right that can be, well, that can be exercised by the occupier of the land, by the owner of the land, or it can be let out to some other person. And the nub of the issue in this appeal, as my lords have canvassed extensively with my own friend Mr Kalinsky, is what is the meaning of that term let out? And we say it's quite simple. It is parting with the right to use those premises, to use that land for the purpose of exhibiting advertisements. So that a third party has that right. And the person who previously had it does not. And 2 points there. We say that on the evidence in this case, and my own friend Mr Flanagan will address you in more detail on the agreement, but it is very clear that only Network Rail has the right to use the locations identified in the schedule to the agreement for the purposes of advertising.
So you said only Network Rail.
Oh, sorry, I meant to say, it has been a long day, I do apologise. Only JC Deco has that right, of course, and Network Rail does not have that right. And that, we say, is sufficient to create the hereditament under section 64.2. And we also say that the right is let out, and it is not necessary to look then to all the case law on whether a right is let out so as to be capable of separate assessment, or whether premises are let out so as to be capable of separate assessment, because all of that case law goes to who is an occupation of something that has been identified as a potential hereditament, and where the hereditament is created under section 64.2, the answer to that question is supplied by section 65.8, which is on page 21 behind the same tab. That right is to be treated as occupied by the person for the time being entitled to the right. So all of the learning on what amounts to rateable occupation, has someone else gone into rateable occupation of a particular part of a host hereditament, has a separate hereditament being created, is not imported, cannot be imported, because the question is answered on the face of the primary legislation. As my learned friend has touched on, as my Lord Justice Holgate drew this court's attention to some 30 years ago, there were difficulties in answering that question prior to statutory intervention in the field of advertising. And there are two references in the case law that you have in the bundle to those difficulties. The first is in Lord Benning's judgment in the Imperial Tobacco case, that's behind tab 19, page 246. And my learned friend is, of course, entirely right that this was not a case about what does letting out mean. I entirely accept that. So 246 is the report page, it's page 192 of the authorities bundle. And it's beginning just above the first hole punch there. Lord Denning says, I would like to remind your lordships that shortly before 1889, the rating authorities had run into great difficulties about the rating of advertisement hoardings. It was never doubted that such a structure was capable of being rated, provided it was so attached to the land that it was not a chattel but part of the hereditament itself. But the difficulty was to say who was liable to pay the rates on it, who was in occupation. And those are precisely the questions that we saw grappled with in the St Pancras case. And my Lord Justice Holgate was very clear on precisely what the considerations taken into account there were. But was it the advertising contractor who erected it, or the occupier of the land who permitted him to put it up? And in 1889, Parliament resolved this difficulty in one way. We know then that was considered not to be fair in all cases, and that in particular attached liability to pay rates for the value of the advertisement, or the advertising use, to the occupier of property who may not be the person benefiting from it. And you see then at the top of page 193, against that background, it was plain that the object of Parliament in enacting section 56, which is the statutory predecessor to the provisions that we're concerned with, was only to alter the instance of liability so as to place the liability for rates directly on the advertising contractor instead of on the occupier of the land. So the purpose of the legislation, and my Lord Justice Holgate drew this court's attention to the same point in O'Brien and Secker, for your Lordship's reference, that's at pages 225 to 226 of the authorities bundle behind tab 21. The purpose was to avoid that inquiry into rateable occupation on ordinary principles and all the difficulties that had thrown up, precisely because of the difficulties of answering it, and to provide that answer. And as we say in our skeleton argument, it's, I think this is a proper use of the word, it is an irony of the appellant's position that it seeks to bring all of that argument, all of that learning back in to the first section, the first stage of identifying the hereditament. So that is the current state of the primary legislation, and that's where the valuation officer starts. Is there here a right to display advertisements that has been let out? Answer, yes. JC now has the right to display advertisements. Network Rail does not. JC is that creates a hereditament under section 64.2. JC is deemed to be an occupation of that hereditament by section 65.8. There's then the secondary legislation, and the purpose of the secondary legislation, as my own friend identified, is twofold. Obviously, the relevant enabling powers are twofold. So you have...
Just before you look at that, you said twice now that the answer to this case is JC has been given the right, and Network Rail has not.
Yes.
Why is it significant on your analysis that Network Rail no longer has a right to advertise? Do you accept that there has to be an element of exclusivity in the concept of let out?
Yes. Yes. So if you say you can advertise, but I can advertise as well, then that's not letting out the right to advertise, that's sharing the right to advertise.
Well, I was going to ask about that.
But then does that tip into the questions of who's in paramount control of the right? Because the network, I mean, the burden of Mr. Lensky's case is that Network Rail do have overriding rights. They're not exercising very much, but they're there.
But they're not rights to advertise. They don't have the right to advertise.
But if they were, if the agreement were, you can advertise for 365 days a year, but we can choose up to 4 days to advertise for ourselves. Would that be a parting with the advertising rights?
Yes, for the 361 days a year.
Because it would be predominantly parting with them. If it were
Well, because it would be parting. So there will be a point at which it becomes simply de minimis, but
above de minimis.
It is a right that is given to another person to advertise, and while that right, during the period for which that right is given, the grantor of that right cannot themselves exercise it.
So if it was just
So it could be
to,
right
to do it on 10 days of the year, that would be parting with the rights.
yes, subject to the de minimis
The advertiser
principle.
would pay the waitable value on 10 days worth of advertising.
But the list is rates is of course a daily
right?
tax, yes. So there's is that right? Hesitant to make overarching submissions about facts that aren't before the court and haven't been tested or considered and may well not exist in real life. A temporary grant of a right to display an advertisement may well not be letting out the right to use the land for the purpose of displaying adverts. It may just be permitting, within your rights as owner-occupier of the land, the erection of an advert. Maybe a potential factual situation. But granting to a third party the right to use the land in general for the purpose of displaying adverts to commercially exploit the available advertising space, unless it's for a period that's short enough to say the de minimis principle will apply at some point. But if there is a defined and ongoing entitlement to display advertisements to the exclusion of anyone else during that period, then yes, I say that is a letting out of that right.
One of the things about advertising rights that makes them different from occupancy of space is that they may take different forms. You may grant someone rights to advertise in a particular way, and other people rights to advertise in a different way, and they may have those in relation to the same physical space.
But there may be.
How does it work in that situation?
So again, with the caveat that this is not a case about two parties having the right to advertise concurrently on the same space, but one can envisage a situation in which it may be, I suppose, in which case my instinctive answer, but I should say I have no instructions on this because it's not a situation the valuation officer has had to consider, is that there may be more than one right to advertise on the same space let out separately.
You could have, I imagine it's only a supposition on my part, what goes on in the advertising world in reality, but you could have presumably a situation where somebody says, I want you, an advertising specialist, to use my parts of my premises for the purposes of advertising, and you will be my contractor, if you like. My agent, I am the principal.
Yes.
You could have, on the other hand, somebody says, I don't want to have anything to do with advertising. I'm letting the right to advertise to you.
Yes.
In the middle, you could have perhaps a joint venture arrangement where it is something you were alluding to a moment ago, the sharing of the ability to write, to advertise, the sharing the right to advertise. And then there'll be a commercial arrangement as to how risk is borne and how the profits are distributed. But your submission here is that when we come to the facts of this
case,
particular agreement, there's only one party who's got
there's
the
only
right
one party who has the right to advertise.
There are other arguments about degree of control, both affecting the advertisement and the surrounding space, but that's a different matter.
I think my lords have now asked me 3 different questions, so I'm going to attempt to answer them.
Different questions.
No, 3 different facets of the same question.
You can imagine different circumstances.
Yes. But so I think that the question of sharing as between the host and the advertiser, and that, I mean, and again, I emphasise not a factual scenario that has been considered, but there may be situations where that's a very fluid arrangement, where there isn't a defined right that is parted with in favour of the advertiser, the host and the advertiser. I say have that kind of perhaps the Ludgate House style, quite fluid arrangement. But if the advertiser has a defined right during particular periods and the host cannot advertise during those periods, then I say the host has parted with the right to use that land for the display of advertisements during that period. That's proposition 1. Position 2, my Lord Justice Holgate. Yeah, I think that was my Lord Justice Holgate's point. I think my Lord Justice Popplewell's point was about more than one advertiser. So the host who has the property permitting more than one third party to advertise on it at different times.
Themselves one form of advertising.
Yes.
But letting out, if it be letting out, another form of advertising.
And again, I say if there is a right to display advertising that is given to another party, third party, that the host does not retain, then again that is a right of advertising, a right to display advertising, careful choose of statutory language, that is let out.
So do we need to just to qualify slightly your definition of let out, which was it's parting with the right to use the land for the purposes of advertisements. Is it parting with a right to use the land?
Yes. So
given that there may be a series of rights which are divisible.
Yes, and that is the language of section 64.2. A right to use So it's not a
Parting
provision that
with
would.
or retaining. Yeah.
Right.
There was a third point, and I'm afraid I didn't write it down, and I can't remember what it was, so I apologise.
One was simply where you employ someone and you're
The
principal,
agent point, yes.
The agent, obviously,
Yes. You're continuing to exercise the right to advocate. Yes, if someone is acting on your behalf and that's a management agreement, that's a management agreement. I should probably foreshadow something that will no doubt come up later, that was the valuation officer's understanding of the arrangement between Network Rail and JC Deco until it saw the agreement. That's the reason, a large part of the reason for the change of position when it occurred.
Because what they saw was the 2018 document, is that right?
Well, they saw a 2018 document for the purposes of, to be careful I get this right, but for the purposes of deciding the issue which was raised, and we've never shied away from this, the issue was raised by the billing authority. They said, we think these advertising sites should be in separate occupation. The valuation officer had until then assumed that there was a management agreement. It was akin to a management agreement and had not sought to separately rate them. They then asked for the agreement, were provided with the 2018 agreement, which was then current, and it wasn't until these proceedings were on foot that we all realised that actually the 2018 agreement wasn't the relevant agreement for the date under consideration.
But I think someone told us that it wasn't in materially different terms from
It's
the
not.
2010 agreement.
It's not materially different for any of the purposes of these arguments.
To understand what the 2018 agreement is doing, you need to see that which it continues, which was the earlier agreement.
I'm hesitating because I'm not entirely sure. I mean, the 2018 agreement could be taken as a standalone. It doesn't refer back to the 2010.
Oh, I see.
It's a new agreement. The 2010 agreement was extended, it was initially for a period, I think 5 years, was extended to 2018. And then the fresh agreement is entered into. Neither party really submits that for the purposes of the issues that you have to decide, there's any... For you, sorry?
No, it's just the 2018 agreement is in fact in the bundle. But
Yes.
we don't say it's relevant, but it's a supplementary bundle 193.
Yes. I think with redactions, is that? Yeah. So you have the unredacted 2010 agreement in the confidential bundle and the redacted version of the 2018 agreement. Rather, just more to do with the refinement of the legal argument and understanding of what was needed from both sides than any material difference between them. It is the 2010 agreement that is the proper focus, that is the agreement that was in force. I think I should also, in defence of all of us involved, say that the evidence was always to the effect that the agreement that had been in place before 2018 was in substantially the same terms. So we perhaps took that on trust, and in any event, you now have the relevant agreement from 2010. So that's management agreement. No one suggests that they would engage section 64(2). So I think then to go back to the secondary legislation, as I said, 2 enabling powers. First of all, that in section 53, and section 53 is on page 12 of the authorities bundle behind tab 1 still. And by section 53, you've seen it already, with the view to securing the central rating en bloc of certain hereditaments, set to state by regulations, designate a person and prescribe to him, in relation to him, 1 or more descriptions of relevant non-domestic hereditament. So, taking section 53 by itself for a moment, that would be possible to exercise that power by prescribing to Network Rail, for example, all of the Setford station hereditaments, but we know that's not the way in which it was done, because there's the separate enabling power under section 64(3) on page 14. Which is the power to make regulations, providing that in prescribed cases, firstly, anything which would, apart from the regulations, be one hereditament to be treated as more than one, anything which would be more than one to be treated as one. And just before I turn up then the current regulations, we say on the face of the legislation and the structure of the legislation, what the regulations we're now going to look at are doing under section 64(3) is dealing with the position that you get to as you work through section 64. Are there hereditaments, or is there a hereditament which would have been a hereditament for the purpose of the 1967 Act, section 115? Is there a hereditament, or more than one hereditament under section 64(2)? Are there any hereditaments under section 64(2)A? And of those hereditaments, it may be prescribed that any one of them should be treated as more than one hereditament, or that any one or more of them shall be treated as one. Any combination of them may be treated as one. So then we have both of those powers exercised in the 2005 regulations, which are behind tab 3 of the authorities bundle, beginning at page 26.
Section 64. I'm just curious about, and I'm curious about two provisions. One is subsection 2A and what sort of meters are being referred to. If someone could help on that,
Yes.
And then we haven't really discussed very much 65(8A),
60.
how that relates to 8. On page 21 of the bundle.
And the short answer, my lord, is it doesn't relate to 8 in the sense of 8 applies when section 64, when the
Yeah, but
right,
forgive me, subparagraph B says this applies where section 64(2) doesn't apply.
yes, exactly.
So I understand that, so I'm trying to grasp what sort of situation falling outside 64(2) is covered by 8A. But
A situation where
we can come back to that. It's a question I asked of Mr. Kalinsky.
yes, no, I'm afraid neither of us has been able to assist my lord particular. I think the
But one situation it would cover is where something is not let out.
Well, it's covering a use of land for the purpose of advertisement, where apart from where that advertisement doesn't amount to rateable occupation.
Which
But there's been no letting out of the right. So it would appear to be covering the situation where the owner is using it for advertisement but no other purpose. And there's a query about whether that amounts to rateable occupation.
C, I was wondering about that, but C says apart from the subsection, the hereditaments are not occupied.
Yeah, exactly that.
So that would be a situation where, for example, the owner of the land is using it for advertisement,
Yes,
but it's not otherwise
not otherwise occupying it. And in that situation, then it's to be, so if not occupied
So it's
by
not
the advertisement,
unoccupied land where the right is being let out.
it's to be treated as being occupied by the advertisement, whether or not that would be right as a matter of if you applied the general law of rateable occupation. I'll see if my clients can provide any advance on that provision. But
So it's doing for advertising rights, is it? What is done for upper land hereditaments in making sure that there is somebody, if it's being used, there is somebody who is rateable, even if it hasn't been let out.
So my lord will be aware that there are different provisions for the rating of occupied and unoccupied land. And what this is doing is bringing land that is only used for advertising unquestionably into the occupied regime and not the unoccupied regime. And just so that everyone behind me has a note of it.
Yes, you're right, because the last line and a half, isn't it? Yeah, that's the obvious. Okay.
And just to say, so that we all have a note of this, we will investigate whether there are any regulations under section 64(2)A about which meters.
Well, just what sort of meters? It looks as if it might be dealing with large scale meters.
Yes.
That's what I'm assuming.
That seems a fair assumption, my lord, but we will check and let you have the fruits of our researches in the morning. So turning up then, I think I can deal with this before 4:30. So turning up the 2005 regulations behind tab 3. You have firstly the exercise of the power to make regulations under section 53(1) of the Act in regulation 3. It's on page 29. Hereditaments are prescribed in relation to the persons named in the schedule. And we can turn up the schedule, but there's no particular issue on that for the purposes of these regulations. It simply prescribes the regulation, the hereditament under regulation 6.1, which we're about to look at, to Network Rail. So then regulation 6, what I can see from the closing words of paragraph 1, which is just past the middle of page 32, the authorities bundle, it's exercising the power under section 64(3) to provide that where hereditament would be more than one hereditament, they're to be treated as one. So that's the structure as between the primary and the secondary.
Can I just go back to the enabling legislation, as it were? Because as my Lord Justice Nugee pointed out, section 53 2A means you only get into the prescription in B if you've already decided that there is occupation of the hereditament.
Yes.
And that's in the context of what's to be on the central list.
Yes.
64 is not, 64(3) is not concerned with the central list as such.
No.
It's simply,
it could make that.
It's simply that there's a power to aggregate or disaggregate hereditaments.
Yes.
So when we get to the central list regulations, is it right to treat them as being essentially made under 53(2)B, but recognising that there is also the enabling power in the central in the delegating legislation to use that for aggregating and disaggregating purposes?
Well, I think that must be right. I don't think anything turns on it.
Well,
it's safe.
Well, it's my Lord Justice Nugee's point that if in order to get into Regulation 6, you've got to get into it through 53(2)B, you do have to have already answered the question.
Yes.
As to whether the hereditament is occupied or not.
Yes. Yes.
For understandable reasons, Mr Kalinsky was rather resistant to.
Yes. My Lord is absolutely right that the occupation words have, in this iteration of the regulations, found themselves in Regulation 6. and effectively regulation 3 would be ultra vires regulation section 53 if regulation 6 did not contain those words, or you would have to treat regulation 6 as containing those words in any event. Because the power to prescribe in regulation 3 only applies to hereditaments occupied by the person in question. Not occupied or owned.
That's picked up in 6.1a, isn't it, of the regulation?
Yes, exactly.
Consistently with
yes.
the enabling
yes.
power.
So, exactly that, my lord. So, to keep it neat, those words, and if one traces through the various formulations from the 1967 Act through the regulations in 1989, 1994, 2000, and these regulations, you can see that those words moving from one place to another, but those words are always there. And our central point is exactly my Lord Justice Nugee's point, that you don't get into regulation 6 if you don't have a hereditament that is either, or if the hereditament that you're considering is not occupied or if unoccupied owned by Network Rail, or let or licensed to the entities that you see in 1 and 2. It's common ground that JC Depot is none of those.
If you have got hereditaments which fall within 6.1a, the end of 6.1 says they must also satisfy the conditions in paragraph 3. Paragraph 3b takes us then ultimately to 4c, to which the appellant is driving.
Yes.
But you're only looking at accepted hereditaments,
yes.
which are accepted from what's in 6.1,
yes.
which is a hereditament and occupied
yes.
by the designated
exactly
person.
That. Yes. And we said on the face of legislation, you don't get past 6.1. I said it was a short point. So,
for the same reason, you say you don't get past 53.2a of the
exactly, yes.
The 88 Act. Yeah.
Yes. So, for Network Rail to succeed, then it has to show either that the valuation officer is wrong about section 64.2, that despite its words, despite the history and the problem it was designed to solve, it does in fact import all the considerations of paramountcy control from the case law on what is rateable occupation. Or they have to show that it doesn't apply in relation to advertising rights at railway stations, because there's a way of reading the regulations somehow that avoids that. What we say is that neither of those attempts to get around what the legislation says on its face withstands an analysis of the words that are actually used in the regulation. This isn't a case where there is ambiguity. The words simply mean what they say. In other words, my next point was to move on to the legislative history. I'm conscious of the time.
Yes,
I don't think that I have more than 45 minutes left. My Leonard Jr. says he has no more than an hour. So that would leave Mr Klinsky plenty of time for a reply in the morning, if we're able to stick to that.
Right. Well, if you're confident of that, we'll sit at 10:30 tomorrow morning.
What rise of April?